И я с удовольствием предоставляю слово Christine Blacklaws, в настоящее время консультанту по вопросам инноваций в сфере юридических услуг, а до недавнего времени, до лета этого года, президента крупнейшего профессионального сообщества британских адвокатов Law Society, это профессиональная ассоциация солиситоров Англии и Уэльса.
Well, thank you very much. I hope that you said the right things in that introduction. I have no translation in my ear, so who knows what you said. I'm delighted to be here, and thank you very much for the invitation. I'm going to talk a little about what is happening in the UK, first of all. Then I'm going to tell you about the developments in relation to the use of algorithms in the criminal justice system. Obviously, Boris has touched on some of our UK examples already. And finally, I'm going to talk a little bit about what's happening. So what are we doing to address these issues moving forward? Legal technology or law tech is really beginning to change and to challenge the traditional systems in which lawyers and law firms deliver legal services. Law tech systems are already capable of performing tasks such as document drafting, legal research, disclosure in litigation, due diligence, and giving legal advice and indeed online dispute resolution, often without the need for any significant human intervention. The potential for revolutionising service delivery and boosting efficiency has led to a real explosion in law tech across the globe. The law tech global market is now estimated to be worth about $16 billion and is growing at a rapid pace. And the development of this law tech sector could provide significant economic benefits for both lawyers, law firms, and consumers of legal services. Cost reductions, of course, but also, and interestingly, the opportunity to deliver legal services in radically different forms. So, the Law Society has placed great emphasis on trying to help our members to respond to the challenges and to the opportunities that law tech poses. And in order to help our colleagues, we undertook a piece of research, which I'm just going to quickly run through. So what we found in our research is that the legal technology landscape is really made up of two main players: big tech, providing technology to law firms, and a wave of legal tech startups, which are providing services to individuals, to in-house legal communities, as well as to traditional law firms. And increasingly, bodies such as the Law Society in England and Wales and other professional bodies are acting as incubators for these startups, providing them with resources, spaces, capabilities, access to depth of legal knowledge. And I'll talk a little bit more about where we're going with that at the end. In the UK, we've seen really two waves of AI. The first was very much rules-based and led to IT solutions such as document automation, legal diagnostics, and legislative analytical tools. But the second and perhaps more interesting way for us has more focused on database predictions to identify outcomes of disputes, analyse documents, and perform legal risk assessments. So our research showed that this has been having a significant impact on our market. First of all, there's an increased pressure for firms based in the UK to use or to enhance their use of law tech. Obviously, there is pressure from greater efficiencies, complexity of work and increasing workloads, but also the changing demographic mix of lawyers, with younger, more tech-savvy lawyers becoming prevalent, and of course, the intense pressure from clients for more for less. we found that significant barriers to adoption remain. So, and that's particularly acute for law firms, although there's this real rising awareness that using technology gives a business a real edge, a competitive advantage. There are fundamental barriers to the adoption of law tech. One of those is about the structuring of the hierarchical structuring and governance of law firms themselves. The fact that law firms are still wedded to the billable hour model. And also in our key decision makers in law firms, a varying knowledge and awareness of what these technologies can do. So in effect, law firm leaders feel very uncomfortable in looking at and utilising technologies. Law tech is much more nascent than other areas of technology, such in the UK, such as fintech, health tech, insurtech, applied AI, and still less disruptive. So we're at the early stages of development. And different sectors of the market are at different stages of their journey. So law tech is much more developed in the business to business area than it is in the business to consumer area. There is some traction in the B2C area. So law firms that in the UK deliver large scale commoditized services, such as in the personal injury area. There's a lot of automation there, but it's really driven by efficiencies. So they're using chatbots, DIY law, robo-lawyers, triage tools, in effect, are becoming much more common with a greater emphasis on the consumer's experience. The other thing that we found was that new skills will be required. So law tech adoption will have significant implications for the future of the law and the legal profession, with new skills, new delivery models, and a new competitive environment all coming into the sector. So what does this mean? Oh, doesn't mean anything. Is that the next slide? No, okay. You're going to have to help me out. I can't read it. Okay, so this should be looking at future skills, yeah? Yep. Great. So the lessons that we learn from the financial sector and management consultancy sectors are important here. And new skills will be required for lawyers. We talked a little bit about this in the introduction, that straddle both technology and law. It doesn't necessarily mean that lawyers will need to code, but it will mean that we will have a much more multidisciplinary approach to the delivery of law in the future. And as I said, that our research evidence that our current structuring is problematic, so we envisage that future service delivery models, so future law firms will look very different to the current law firms. And we see that already with the big four accountants, with alternative legal services providers coming into the market, and other new entrants. So, and one other thing I wanted to mention here is that adoption of new technologies could really shake up the incumbent legal service market. So it may mean that it could lead to a sort of David and Goliath situation where smaller, more boutique law firms can adopt technological solutions and really, as we would say in the UK, punch above their weight, be able to compete with much larger businesses in a way that hasn't been possible before without armies of paralegals. The second thing I wanted to move on to is to discuss the work of a commission which I had the privilege of chairing this year. this is, again, a Law Society commission. The rapid growth of the use of AI and algorithms across all areas of public and private life has promoted plenty of debate and no little concern in the UK. And whilst technologies can, of course, revolutionise the way that we live our lives, for obvious reasons, a lot of our focus has been on the potential dangers posed by a technologically integrated future. So the speed of technological innovation and adoption in recent years has posed new ethical, legal and societal challenges and prompted us to ask many challenging questions. Is artificial intelligence a potential force for good or an unacceptable risk to human rights? Is it right to allow machines to take over some judging functions previously entirely reserved for humans? Do we need to regulate or even restrict the use of algorithmic determination in public institutions? So, amid an often febrile atmosphere, we wanted to separate the hype from the reality. So we set up the Technology and Law Policy Commission. It was very much a multidisciplinary commission. I chaired it as a lawyer. My co-commissioners were a professor of computer science, professor of ethics. And we chose to focus on the criminal justice system as a whole because it's this theatre which most of the risks associated with the use of AI are playing out in the UK. And of course, as we know, erroneous decisions here can threaten human rights and undermine the rule, and in some jurisdictions lead to not only just the loss of liberty, but the loss of life. So our inquiry saw us holding 4 public evidence sessions. We interviewed over 75 experts, and we read over 80 written submissions for this commission. So we received a wide range of views from different disciplines and sectors, including computer science, regulation, ethics, policy, human rights and civil liberties. And we had 3 main findings from our report. First, that there is widespread use of algorithms in our criminal justice system. We have in the UK 43 different constabularies in different geographic areas. In 25 of them, we found that there was the use of algorithms in terms of algorithmic determination in a criminal justice process. And we produced a heat map if you want to see it, and the report is also available on our website. The way that algorithms are being deployed was impressively varied, with current applications encompassing things like photographic and video analysis, facial recognition software, which we've discussed a bit, DNA profiling, individual risk assessment and prediction, predictive crime, mapping, mobile phone data extraction tools, and data mining of social media and the intelligence that comes from that. So across our country, officials and authorities in the criminal justice system are all using some form of technology in different scales and different applications to support determinations in the criminal justice system. Boris has already talked about Durham Constabulary's heart assessment risk tool. And this tool, this algorithm, analyses the risk of re-offending to inform decisions about whether or not to keep a suspect in custody. And over a 2-year trial period, it had some good results. Facial recognition technology has been much less successful. It's been deployed by several police forces across the UK. And what it does is it cross-references images of people's faces with watch lists. When it was deployed at the Notting Hill Carnival Festival in London, it had a 98% failure rate. When it was deployed by South Wales Police at a big sports match, it had a 91% failure rate. However, as we all know, the technology is is the worst it will ever be right now. So I don't think we should throw the baby out with the bathwater, but it is a serious consideration when it comes to individuals' civil liberties. Of course, there are significant benefits to be gained by the use of algorithms in the criminal justice system. Automation of rote services, form filling, checking, information retrieval, dissemination, improving efficiency is very valuable, particularly for our often straitened public bodies. And of course, more granular technologies can actually augment existing systems to allow us to facilitate a greater degree of scrutiny of existing processes and outcomes. And machine learning algorithms are able to analyse cases, objectives and individuals on a much deeper level and open up the possibility of individually tailored interventions. But they can also be used, for example, to leverage points in criminal networks most likely to disrupt their functioning. There's a lot to be gained out of this, but equally there are still many concerns. And one of the ones we were most worried about was a lack of explicit standards and a lawful basis for the use of algorithms in the criminal justice system. This is so concerning because the stakes, as I said before, are so very high. And during the course of our research, we became very heavily concerned that some systems and some databases operating in the UK today, such as the mobile phone data extraction and facial recognition technologies, lack a clear and explicit lawful basis. So opaquely designed algorithms deny individuals the ability to assess whether or not an algorithmic decision is legitimate, justified, or legal. And this opacity can emerge from secrecy in the development and design stage, or a desire by private developers to protect their intellectual property, or simply due to the complexity of the algorithm itself. And these issues need to be urgently addressed. And thirdly, we found that algorithms are not being critically assessed. And this is creating a number of risks to the justice system and to the rule of law. Whilst many of these technologies are in pilot or experimental stages, they are not so technologically novel that they can't be critically assessed. In other words, they should be subject to scrutiny. And this scrutiny needs to be led by experts from different teams to focus on the conformity of algorithms to real challenges and the potential for unintended and undesirable side effects, particularly the possibility that they may, in some circumstances, prioritise goals or values to the detriment of others. And this is generating significant risks in three main areas. First, a risk to fairness. So algorithmic systems encode, hardwire assumptions and systemic patterns which can result in discriminatory output. So the way that the data, the input is measured, is labelled and classified is subjective. It is dependent on the programmer, and you can really embed bias at that point. The training data is also problematic. It's almost certain to be biased because we live in biased societies. So there's no way in criminal justice to truly measure the crimes that are committed in society. We have proxies, but those proxies are problematic. You can look at perhaps convictions, or even more problematically, at individuals who have been arrested or charged. And if in the UK, and I'm sure across many jurisdictions, it is commonly accepted that the justice system underserves certain populations and over-polices others, these biases will be reflected in the training data. So you can imagine a situation where we are embedding those biases for all future decision making if we don't get this right. There's also a really significant risk to human rights. Algorithms rely on data identifying shared characteristics and patterns to reveal those insights that we crave. And in doing so, algorithms naturally categorize individuals into groups without much personal consideration. Machine learning also presents a real risk to the human right of privacy. And there are examples of machine learning that can infer data or behaviours which are would be considered by all of us to be very private from seemingly non-sensitive, publicly available data. So there are some real risks there. The third and final risk is a risk to the effective delivery of justice and the rule of law itself. And certain witnesses told us about a real possibility of having dehumanized justice. One of the chief constables who gave evidence noted that in his constabulary, human decision makers lacked the confidence and the knowledge to question or to override an algorithmic recommendation. So what are we suggesting that we need to do about this? What we need is a range of new mechanisms and institutions to improve the oversight of algorithms. In the UK, this is about enhancing the authorities that we have already, as opposed to building new organisations to deal with this issue. So our Information Commissioner's Office, our Centre for Data Ethics and Innovation really need to be beefed up. And we believe that we need to create a statutory code of practice for algorithms in the justice system. And this would be under our Data Protection Act and regulations. And we also want to create a national register of the use of algorithms in the justice system. There is just too little that we know, too much opacity about what is going on, and that cannot be in the public interest because we are talking about public institutions. And secondly, we recommend the clarifying and the strengthening of the protections relating to algorithms. So this is again about using the mechanisms that we already have in place. We undertake assessments at the moment, impact assessments in relation to gender, for example. We should now utilise the methodology to get data protection impact assessments and providing and ensuring that we have really meaningful human intervention in algorithmic decision making. And looking beyond data protection, existing regulations concerning the fairness and transparency of activities in the justice system need to be strengthened. So equality impact assessments should be introduced for the use of algorithms in the public sector. And thirdly, there needs to be real consideration given to the procurement of algorithmic systems. In the UK, these are private companies that are selling their software to public institutions. So we need a statutory procurement code and a review into the policy options for mandating human rights. And something that we haven't talked about yet, explanation facilities, so that individuals can understand how a decision has been reached and assess whether they should seek a remedy through the courts. And fourthly, and obviously, that all algorithms used in the justice system have to have a clear and explicit basis and law. And finally, that our public institutions have to develop their own in-house capabilities to be able to understand, to scrutinise, coordinate the appropriate use of algorithms. At the moment, there is a real risk because they are entirely dependent on those external for-profit agencies that are selling the software into them. And for public institutions making such important decisions which are about fundamental human rights and civil liberties, it is vital that they have that capacity in their own in their own organisations. I'm going to, if you might indulge me with 5 minutes, just to very quickly run through some of the things that we've set up in the UK to try and deal with these. So I've mentioned that law tech provides a major opportunity to revolutionise the delivery of legal services, and to help seize this opportunity, but also to ensure that we are developing the right legislative and regulatory framework. We have, the UK government has set up the law tech delivery panel, and I have the great privilege of chairing this panel, and of also chairing the ethics task force. But we are looking at issues such as regulation, education, the future of legal services and skills acquisition, investment and commercial dispute resolution. And we've also been looking at it from a UK jurisdiction perspective. So next month, one of the first things that we're doing is launching a statement. This statement will give clarity about how UK jurisdiction will deal with crypto assets and the use of crypto assets and the use of smart contracts. So within the common law English jurisdiction, and those are the people on it. Another body that I again have the pleasure of chairing is part of Innovate UK, and this body we've given out £20 million in collaborative research and development across law, accountancy and insurance, and we are in the process at the moment of looking at another £3.5 million that we're going to be giving out to analyse data access and data sharing, because this is one of the biggest problems that we face actually in the UK and in terms of all jurisdictions, to be able to access and utilise the gold mine of data which we sit upon to create those insights. We have, I mentioned before about incubators, so we've set up with Barclays Bank, one of our global banks, one of the very first, or the first in the UK, industry-specific law tech incubator, where we have 20 law tech businesses and we're working with them and supporting them. And in the access to justice area, I sit on a government panel again, where the government has given us £5 million to look at how we can utilise technologies to bring about greater support in access to justice. So I just wanted then to finish with a reflection that these issues, these problems, these challenges and these solutions are no respecter of international boundaries. It is vital that we all work together to establish common standards and common solutions. And so I very much look forward to participating in today and to hearing from the other wonderful participants and from the learned audience, and to take home, I hope, some great ideas. Thank you very much for listening.
Кристина, нам нужно, видимо, несколько секунд, чтобы осмыслить объем финансирования исследований в Соединенном Королевстве. Перевести фонды более нормально. И теперь можно задавать вопросы.
Christina, first,
We need the mic.
Could you please turn off the mic? Thank you. Thank you very much for your very valuable presentation. Her name is Nikolai, I'm from Lomonosov University in Moscow. I realized that I have a question both to you and to Boris. How do you think what way of law enforcement or law implementation is more predictable by robots or by humans?
Typical lawyer answer, it depends. I think that there is the opportunity with the appropriate use of technology to bring about a level of consistency in law enforcement, and I would add there in those would be controversial court proceedings that we have never experienced, and that can be regionally, domestically, it could be indeed internationally as well, once we can start to mine data that gives us those insights. I think there is an issue of societal appetite and readiness here as well. So we as societies have moved to a much readier acceptance of automation in our lives, and I think that we have further to go yet. However, at this point, and probably quite some way into the future, I think there will be certain decisions that we would feel uncomfortable about delegating entirely to a machine, and decisions about custodial sentences, about convictions. I think it will be some time down the line before we are willing societally to contemplate those being delivered entirely in an entirely automated fashion. But as I say, we mustn't throw the baby out with the bathwater here. There are aspects of policing and aspects of decision making in the criminal justice process that we really should be investigating as to how we can.
Yeah, I have little to add. I fully agree that it depends indeed. The matter is that whether predictability is always good. So that's a question. I don't want to mention some particular countries, but when it comes to some member states of the Council of Europe, so we know what kind of judgments will be made in advance. And this doesn't matter whether these judgments are made by humans or by artificial intelligence. I would say that this is one of the aspects of a broader issue. I would say that the key issue of, when it comes to judiciary, how to reconcile two basic principles, independence and accountability. And probably this goes beyond this the subject we are discussing here at this conference. But I would like to stress to finish this issue that so far we are not speaking about robots taking decisions. So far, as Christina said, this is only consultation at best. what all AI system can provide. And anyway, the responsibility always lies with the humans, at least so far.
My name is Paul. I'm from Russia. Can you give us an example of a legal chatbot in case of criminal law? Not for professionals, not for lawyers, but for common person. For accused common person.
So, in fact, Roger and I were talking about this very subject yesterday. It is developing in the UK. So I talked about the use in relation to personal injury cases. There is also development of chatbots in relation to family law cases, housing, social welfare cases, that sort of work. However, I'm not aware of any chatbots that are being used in criminal law proceedings. Not yet. But what a chatbot gives a person, an individual, is the ability, hopefully at zero or no cost, to better inform themselves about their situation. Not only no cost, but also no commitment. So it isn't, you can imagine, I can imagine a chatbot that could give an individual some very helpful advice and support, particularly about lower level criminal activity. We talked about, and Boris was saying quite rightly, that there is no fully automated decision making in the UK about criminal matters. However, there is a lot of automation around parking fines, speeding fines, and again, if we test this society, we probably are okay with a fully automated process when it came to the offence of fishing without a fishing licence, for example. Although we don't have it just yet, I would imagine that we might do, and that if there is that process, chatbots would be the mechanism to enable people potentially to make decisions for themselves about how to deal with that very low level of quasi-criminal activity.
Еще раз представлюсь. Нина, Санкт-Петербург, Северо-Западный институт управления. Спасибо большое за информацию еще раз. У меня такой вопрос. А существуют ли какие-то информационные технологии, направленные в отношении несовершеннолетних, в том числе несовершеннолетних правонарушителей? Спасибо.
Again, a very interesting and challenging area. So there is a higher degree of reluctance, I think, when it comes to more vulnerable groups and to applying technological solutions to their issues and problems. Having said that, one of the programs which has gained some funding, a chatbot, is designed to support people with mental health problems. So there are, in other areas, there are attempts to help and support vulnerable people, but I think when it comes to youth justice, there is a real concern that vulnerable and young people need face-to-face support. It would be interesting to argue it the other way, to say that young people are much more comfortable with digital interaction and digital solutions than people of my generation, and that actually it might be more accessible and more appropriate for young people to interact with a justice system in that way. But I don't know that that argument has been made in certainly not in the UK.
I really appreciate your question for wonderful overview. And I can't agree more that we need such kind of register algorithms. The problem is we don't have enough information about those algorithms. And I'm afraid public officials will not be ready to share this information. So the question is, what kind of tools do we have to make them to disclose this information? Again, about the influence of society.
Yeah, and you're absolutely right. What we can report on, what we reported on, were the uses that we were aware of. There may be other uses that we have no insight into because there is no requirement for disclosure. And as I set out before, this is compounded because we have no one authority. We have 43 different authorities who effectively operate within a system but with a lot of autonomy on their own. So it makes it even more challenging. That is why we need legislation. And it is particularly important for public institutions and of course at the very cutting edge of what public institutions can do in the criminal justice system. And I would anticipate that if legislation is put in place, then our public institutions would comply with that legislation.
Большое спасибо, Кристина. Большое спасибо. У нас сейчас пока не остается времени на вопросы, но также обязательно будет. В чем некоторые преимущества работы с алгоритмами? Алгоритмам не требуется обед. С другой стороны, в этом их недостаток. С ними совершенно невозможно неформально пообщаться за обедом. С юмором все-таки пока еще можно.